Hi, everybody. While we are waiting for more people to log in and more coming in physically, we wait for 2-3 minutes. It's very noisy in my office just now. I keep reminding that this is a talk, not a party. So we all have to behave, and we will wait for a few more to join before we start. So please bear with us. Okay, I think we should start now because today we have very heavy information flowing around from different jurisdictions other than those sitting in front of me. So first of all, thank you very much for attending the talk today. We have over 130 registrations for today's event. This is amazing, and we have a few more coming in, and they are grabbing a glass of wine. So today's topic is the debt factor, breaking down barriers in relationship breakdown. First of all, we will record this session, and we'll send you a link if you want to rewatch again, and we'll send you the slides if you think you want it. But in any event, first of all, I need to send my greatest gratitude to my panels in front of me. We have different jurisdictions. And first of all, I would like to introduce Mr. Michael Hartman. He doesn't need any introduction at all because we all know him, but I still need to introduce Michael. Michael was a non-permanent judge of the Court of Final Appeal since 2010. He joined the Hong Kong Legal Department in 1983 as a Crown Counsel. Later, he was appointed Senior Crown Counsel in 1984 and Deputy Principal Crown Counsel in 1989. In 1991, he joined the Hong Kong Judiciary as a District Judge, later appointed a Judge of the Court of First Instance in 1998. From 2008 to 2012, he served as a Judge of Justice of Appeal. During his career as an honorable judge, he has written a lot of landmark decisions on families and children's matters. So, Miss Wong
Very manly.
She's from Singapore. Kai-Yun is the co-managing director in Chow Wong Chambers, LLC. Co-chairperson in Family Law Practice Committee of the Law Society of Singapore, and a president-elect of our International Academy of Family Lawyers. She has been in practice for close to 30 years and maintains a niche focus on private wealth and family matters. Her family law clients comprise largely high net worth individuals with concerns over financial settlements as well as cross-jurisdictional issues. From its inauguration in 2013 to date, Kai-Yun has been honored as part of the City Wealth IFC Power Women and was included as one of a selected few of Singaporean lawyers listed on the City Wealth Leaders list. She was also named in the Doyle's Guide for Family and Divorce Lawyers from 2015 to date, as well as consistently nominated as a litigation star in Benchmark Litigation Asia Pacific, including the 2022 edition.
Yes,
Eleanor Lau is currently a partner in Lender & Rogers, Australia. She will be promoted as an equity partner in July. She's an accredited family law specialist who practices exclusively in family and relationship law. She assists clients in all areas of family law, including property settlements, spousal maintenance, parenting matters, financial agreements, child support, and international family law matters. She is also experienced in complex parenting matters, particularly in cases that cross international jurisdictions. At the same time, Eleanor is a member of the Specialist Accreditation Family Law Advisory Committee, which is responsible in overseeing and assessing other family lawyers in gaining their specialist accreditation. She is recognized by Doyle's Guide as a leading family divorce lawyer in both Australia and New South Wales. Eleanor is also named by Doyle's Guide as a leading family parenting and children's matters lawyer in New South Wales. Marvelous. On the screen, Jason. Hello, Jason.
Hi.
Jason is a senior partner in Lending Law Officers PLC. He assists clients in areas including cross-border inheritance, estate planning, divorce, offshore trust settlements, inbound and outbound investment, as well as civil and commercial litigations. Before joining Lending, Jason has worked as an in-house counsel in multinational company and attorney at law in several international law firms. His experience in complex inheritance matters, particularly in cases that cross international jurisdictions. He is also a lecturer at the Law School of East China University of Science and Technology, affiliate member of Society of Trust and Estate Practitioners. So it's that. In short, it's that. Okay. So let's give a warm welcome to Jason.
Very simple, right?
Last but not least is our Natalie Long, who has also been just promoted as senior associate. Natalie is our senior associate. She's qualified in Hong Kong and is an active member of the Hong Kong Family Law Association. She advises on all aspects of family law, including nuptial agreements, divorce, and disputes relating to children and matrimonial finances. Her civil litigation experience includes handling general commercial disputes and professional liability claims. You should be careful. Her clients are ranging from ultra high net worth individuals, entrepreneurs, city professionals, private banks, global accounting firms, multinational insurers, and Hong Kong law firms. So I think I've taken up a lot of your time. Without further ado, I want to pass the floor to Mike.
Well, hi everybody. Now comes the dull bit, I'm afraid. I've been asked to moderate this evening's talk. And can I say that as a retired judge, every time there are disputes over parental responsibilities involving a husband or a father, they always appear or have appeared to be problematic. It's a kind of instinctive thing. And that's why I think this evening's talk is really important, because so many of us immediately think, oh, now we've got difficulties. Whereas there should not be difficulties. There should be principles that guide issues. And that's why this evening we're going to hear from Singapore, from China, from Australia, and from Hong Kong as to their own legal structures that concern the rights of fathers in respect of parental responsibilities, and also as to the approach of the courts of those four jurisdictions that arises out of their legal structures. So without any further delay, I'm going to get on to the first jurisdiction, and that is Singapore. Yes, Kaina.
Thank you. Now, if you took a leaf from what Rita was reading, you really shouldn't believe everything that's being read to you, because that's what it's like when you read the statutory provisions in Singapore. I mean, when I look across the room, there are people whom we have had cases with, right? Whether you've sent your kids to us in Singapore or we have sent kids to you in Australia. And that's why the provisions are sometimes misleading. So what do the provisions tell us? As with everybody else, we subscribe to the best welfare of the child. And in our Women's Charter, which would apply if you were going for a divorce, the wishes of the parents are taken into account together with the wishes of the child. If you were applying for custody, care and control, access, relocation without a divorce, you might do it under the Guardianship of Infants Act in Singapore, which again says that you should have the welfare of the child as the paramount concern. But it also states the father of an infant shall not be deemed to have any right superior to that of the mother, nor shall the mother be deemed to have any claim superior to that of the father. So very equal sounding, very principled, as Michael would say it. But there's always a but, right? What do we have? We have, as you do in Hong Kong, the fact that there is custody, which is merely decision-making, and it's not physical custody. For us, physical custody is surprisingly a very different English word. It's called care and control, and that is who the child would be staying with. And in our cases, access is defined as allowing the spouse not having care and control to maintain regular contact. So off the cuff, when you looked at the definitions, even though we may say that the father does not have better rights than the mother, and the mother will not have better rights than the father, but because of the way the balance is, like it or not, somebody will have the better fruit. Somebody will have the care and control, and somebody who does not have the care and control will merely have access to maintain regular contact, right? What are the relevant factors when we assess this exercise? Have we clicked ourselves there? Okay, the relevant factors are conduct of the parties, wishes of the parents, and wishes of the child. A young child would be best looked after by mother. Which party can offer better security and stability? Siblings should not be separated. Again, on the face of it, if you read it, everything seems to be very principled, very equal. What's the problem then? The problem are the people applying it, those who are the counselors who then make the recommendations. See the human factor that's at play. Right, the counselors who make the recommendations and the judges who decide it. Because at the end of the day, we all apply the law through a certain lens. Okay, and do I move on to the next slide? Yes.
Relevant factors.
Oh,
That's it.
okay. Yeah, that's the relevant factors. Okay, I was told to quickly talk about, is there a difference between married and unmarried couples in Singapore? Again, on the face of it, next slide.
Next.
No, before that. Oh.
There we go.
Okay.
fundamental difficulty of understanding terminology. Is there any move in Singapore to try and modernize the terminology?
In fact, that's an ongoing thing that we are doing, and there are moves for reform to change the terminology. We are slowly edging towards enlightenment. But the problem remains that no matter how you call it, at the end of the day, we are very far from having a recognition for equal times or substantively equal time between father and mother. So that's another conversation altogether.
Okay, good. That I think sets out your legal structure there. Can we move on, maybe, do you think, to the next one so that we
Okay,
have
I will just have a quick one on this.
Okay, good.
Okay, so I was going to say, on the face of it, our married men and unmarried men appear to have the same rights over children, but that's not always the case when we go to court. In fact, for the fathers, what we often do in Singapore, because it's so hard to get sole custody, we are all trying to push for shared care and control. I will talk more about it later, but as a result of those efforts, it was actually reported in the papers that the percentage went up twofold, right? From 5.6% to 9.5% of all our cases. 9.5% of the fathers now have shared care and control. Okay, so not figures that will go hoo-hooed about, but it's movement.
Okay, good, thank you. And we can move to
Jason.
Jason. Jason, can you hear us?
Yes, I can.
Okay, can we hear you?
Okay, talking about China's law regarding father's rights, it does not sound any better than Singapore. It would be worse, actually. Well, as a general, before I dive into the law, I have to mention one thing. Because today, I think we are more concerned with the cross-border family law, cross-border cases. But in China, when you're dealing with the court, dealing with a cross-border, or we call it foreign-related case, the judge will always to look at which law, which applicable law should be applied in this case. And our law, our private law, or the law on choice of applicable law has very, very good provision on the books. But in practice, what we see in the China court, when it comes to a family law issue, either about community property or child custody or care and control, the law is good, but in practice, China court will always find many excuses to avoid using the foreign law. So it ends up that all the cases we have researched, the China law are choosing as the governing law. So from there, so I would just tell you how the Chinese law works, in our judicial system. Okay. Generally speaking, a father has, the kind of equal right to divorce, to division of community property, to child care and control, to visitation and or access. But again, here I want to emphasize that in China, our court, when dealing with the divorce cases, the court does not deal with the custody issue. Okay, custody is not a matter to be dealt with in a divorce proceeding. Only care and control, or sometimes we can translate the term into a physical custody or direct custody to be separate from legal custody. But anyway, it means which parents the child will be living with. Okay, I think that's very much equivalent to the care and control in Hong Kong and probably in Singapore. Yeah, and when it comes to in practice, when it comes to parent control, decide which parents the child will be living with, and it's not surprising that in many cases the mother are awarded with the parent control cases. As we've seen from one of the white paper published by the Shanghai Intermediary Court, it seems that up to 75% of cases in which the child parent control are awarded to the mother instead of the father. So you can see, the imbalance here. But you need to also notice, take a note that under Chinese law, when the children are below 2 years old, the law make it compulsory, make it mandatory that the parent control should be awarded to the mother. Okay, but for children who are 2 to 8 years old, it's up to the court discretion to decide, comparing the parents' condition, apply the so-called best interest of the child, and decide on which parents the kid will be living with. And if the kid is 8 years old or older, the court will also take into account the wishes of the child himself or herself. So, but overall, it ends up that the mother are getting more care and control, successful in getting care and control over their child. And as Ken Yun just mentioned that in Singapore, probably it's not very the shared parenting or the equal sharing. It's not very common, but it's the same case in China. And actually, in many cases in China, when it comes to visitation or access by the left behind parent, the general rule is once or twice a month. Okay, for the parent who does not have parent control. I think it's far from enough, but that's the general practice here in China. Okay, but if you sometimes we argue to we call it rotation custody or rotation care and control, where each parent will take care of the child for a certain amount of time, but probably because of the practicalness, it's not very convenient. The law says only upon the mutual agreement by the parents can rotation care and control will be awarded. That means if the parent does not agree, the court will only award care and control to one parent. Okay, but we are talking about here we are talking about the urban Shanghai, the landscape about the cases, right? But if you look at some rural area in the rural area of China, probably it's different. But I think the rural, the judicial practice in the rural area is not very relevant to our today's talk. So I'm not going to go into more detail. So yeah, that's basically one more thing. As we have seen in the cross-border divorce cases, very often white parents we have to leave their child behind in China. We have dealt with several cases where the only thing the parent that go out of China will rely on the video access, which I think I don't know how the other jurisdiction will deal with such a situation. But anyway, when it comes to international divorce, so the white parent's heart must be broken when you have to leave the child behind in China. Okay, so much for me here.
Good, thank you very much indeed. Thank you. And now if we can move on to Hong Kong, home turf. Yes, thank you.
Thank you. So as between married parents in Hong Kong, we still have the terminology custody, care, and control. And for many of you in the audience, you'll be already familiar with what this means. But for the benefit of those in our audience who are not lawyers, the term custody is not actually defined in our statute. Under case law, the general definition is that it relates more to the modern concept of parental responsibility. As for the concept of custody in practice, we find that the term suggests or has a connotation of ownership or physical control over a child. And because of that, I think many clients and many people believe that if they get sole custody, that means they have the right to control everything. They can make unilateral decisions about the child's education, their health, their religion. This is a misunderstanding. Neither parent actually has a preemptive right over the other parent. A sole custody parent does not have absolute authority to act without regard to or reference to the non-custodial parent. The non-custodial parent still has the right to be consulted, and he or she can issue applications to the court if they believe that it's necessary in the child's best interests. So nowadays, the court generally assumes that the well-being of a child is best served by having a healthy relationship with both parents. And so the most common type of custody order we see is a joint custody. Yeah.
Good. Excellent. Yes.
On to next slide. So here we've also set out the definition in law and the definition in practice for care and control and access. Care and control has, I guess, two levels of meaning. First is care control means is with the parent who is physically with the child at any given time. So this can mean whether at home or during access visits. And it refers to the day-to-day care of the child as well. So getting the child ready for school, making sure the child is fed, does his homework, and so on. And access refers to the time that the child spends with the non-care and control parent, the non-primary care parent. Neither of these terms are defined in our statute. As for unmarried parents, so in Hong Kong, the infrastructure and the law still, I guess, discriminates against fathers of children who are born out of wedlock. In our experience, there are many people who believe that there's a concept called a common law marriage, or they assume that regardless of their marital status, they automatically have parental rights in respect of their biological child. That is not the case under Hong Kong law. You need to take proactive steps to be formally recognized. But after these orders are obtained by the Section 3 declaration and the Section 6 declaration, then the same concepts of custody, care, and control apply.
Good, excellent. Australia, interesting changes in Australia over the last decade or so.
Yes, Michael. So as one would say, we leave the best till the last. We don't have as many legislations as our Singapore friends do. We don't discriminate between unmarried and married couples or parents. We don't have this concept of custody, care and control and, you know, all these different buzzwords. What we have in our Australian Family Law Act is that it provides for parents to have what we call parental responsibility. There is a presumption in Australia that parents have what we call equal share parental responsibilities. It is the same for what we call de facto couples, so unmarried couples, as well as married parents. As I mentioned earlier, there is a presumption that when parents are separated, they have equal share parental responsibilities unless rebutted otherwise. It is often very difficult to rebut that presumption. And, you know, cases that I've done before, you're basically looking at, you know, one of the parents is in jail or have really, really significant domestic violence issues in the case, really serious abuse issues. Otherwise, that presumption stays. Similar to our friends in other jurisdictions, the paramount consideration in parenting cases is what is in the children's best interest. So I guess turning to the topic that we have today, Michael, the highlight from an Australian point of view is that we don't discriminate between fathers and mothers. They are treated as having equal shared parental responsibility. What then that means to us is that the approach when deciding the sort of time that children are to spend with the parents following separation, the legislative pathway is that we go to those. Yep. So the legislative pathway is that if the presumption stays, so parents have equal share parental responsibility, then we look at whether it is in the children's best interest to spend equal time with both parents. Now, equal time can take different forms. It could be a week about type of arrangement. It could be 7 nights in a week. You have 4 nights, I have 3, and then we swap it over the following week. If equal time is not in the children's best interest in a particular case, then we look at whether or not it is in the children's best interest to spend what we call substantial and significant time with one parent and live with the other. Substantial and significant time means usually alternate weekends, so from your Friday after school till your Monday before school type of arrangements. On what we call the off week, so you don't get the weekends, you get some weeknights. We share school holidays, we share special occasions, etc. So that's basically the framework in Australia in terms of how we deal with parenting matters.
Okay, I'm sure everybody here will remember a couple of decades ago in England, there was a group of radical fathers who climbed Buckingham Palace and put flags up and everything else, seeking rights of fathers. And I may be wrong. I'd be careful about my grasp of the accuracy here, but I understand that the changes made in Australia, which gave fathers more equal time with the children, that also came through legislation and a body of fathers, presumably, or representatives of fathers, who sought some change. Is that right?
I think you might be right. So it's after a lot of lobbying, so our legislation changed.
Okay, and to what extent have the courts followed that? Is it with Nelson, like a blind eye, or have you actually said, no, this is a good thing and we need to follow it?
Well, I think if we look at the next slide, there's some statistics that I've put up there. So the majority of the cases that end up in court result in the mother having sole parental responsibility, so a sole parental responsibility order. About 11% of the cases that go to court end up with the father having sole parental responsibility. So
and just remind us again, sole parental responsibility.
So not equal. So sole means mum or dad having the sole responsibility to make all long-term decisions for the children. Good. So long-term decisions typically are what I call the important decisions. So which school they go to, important medical decisions. You can't go and change the names, where they travel, where they live. So if you have a sole parental responsibility order, then that parent gets to make all the calls in relation to those.
Right, but the other parent still gets time with the child.
Correct. So parental responsibility doesn't necessarily mean time. Those statistics do look like, even though you go to court, mums still get the sole parental responsibility order. But we ought to remember that these are cases that actually went to court, so all the way to a final hearing. Only 3% of cases really go all the way to a final hearing. Most of the cases do settle. It is extremely rare, the statistics tells us, for the court to make an order for one parent to have no time at all, so 3%. I guess for the purpose of our talk today, importantly, 41% of cases that go to court provide for equal time between the parents.
So those would be cases where the parents are going to court to fight over
for the
time with children.
Correct. Okay. Correct. So 41% gives the parents, mum and dad, to have that equal time arrangement with their children. So recent statistics also tell us that arrangements where children spend most of their time with their father are more common in orders made where litigation occurs, as compared to parents that don't go to court. So if the father wants to fight for equal time, looks like they need to take it to court.
Okay, yeah, well, yeah.
Can I ask a question on
Sure.
that? In the 41%
Yep.
equal time,
Yep.
is that literally equal time?
Yes.
Or is that also,
No.
does that include the substantial and
No,
significant?
equal time. So a week about or 4 3 nights swap around type of equal time.
Or as equitable as it can be, with the parents agreeing how it works best for them.
Yeah, so it's actually having the same amount of time between the parents. So not substantial and significant time that I was talking about where you get a night or two less than the other parent.
Okay.
We actually have the same amount of time with the children.
And has this resulted in any social difficulties in Australia? Parents marching or anything like that?
Not really. I think as a family lawyer, the difficulty seems to arise where, because our legislative pathway, as you would have heard, is so different from our overseas jurisdictions. And nowadays, families are more and more international in the sense that, you know, I act for a lot of clients who may have came from other jurisdictions. I think it's difficult to grab the concept of, you know, there's no custody and control anymore in Australia. You can't make all the decisions on your own. You actually have to share those responsibilities with the other parent. And then, you know, you might end up with having equal time.
I'll give you that. Sorry. Yes, sorry, that didn't.
That's okay, no problem. But I've put, I mean, when the slides are being sent to all the audience, I've put up some cases from the last 12 to 18 months where final orders were made by the court for the children to actually live with the father and for the father to have sole parental responsibility. And when you read the facts of those cases, unfortunately, in the examples that I've put up, they are situations where there were allegations of abuse by the mother against the children, or, you know, the court found that there was an acceptable level of risk against the mother in those cases. In one of those cases, the court found that the mother was unable to facilitate a meaningful time between the children and their father. And in those circumstances, the father successfully obtained a sole PR order and the children live primarily with the father.
Okay, yeah, that's interesting. Most courts in all jurisdictions, I think, will have situations where the parties, that is the husband and the wife, are fighting each other through the children. And, for example, will deny access to that's been awarded by a court because suddenly the children have got piano lessons or they've got soccer lessons and they keep the other party running. And in England, there was at one time heavy criticism of an English family court where the judge in the family court simply said, the one party has been so difficult, we've made so many orders that there's nothing more we can do. And just gave up, essentially, washed their hands of it. That came up at a time when I was at a conference relating to family matters, and the Canadian judge there, a federal judge, said, in Canada, we deal with it very simply, as you do there. If the one parent is not able to attend to the child's best interest by allowing that access, then we move the access. Sorry, we move the care and control to the other parent. And I just wonder, would that happen in Australia quite regularly?
It would. So sometimes, again, going back to the topic that we have today, sometimes when you act for the father, typically after separation, if the mother has always been, the primary carer, mum may make it difficult for the father to spend, substantial time or even equal time with the children. It is a process to sort of go through where in our system we involved what we call single experts. So they usually counsellor or psychologists, do reports and so forth. And sometimes when it's identified in those reports where mum has failed to or unable to facilitate a meaningful relationship between the children and the father, then there comes the argument where, on a final basis, you might argue for a change of residency for that reason.
Okay. And that would happen equally the other way around.
Absolutely.
If there was an instance, for example, of parental alienation, every time the children were with the father, for example, that he was doing his very best to subvert the mother's position, asking about the mother's new boyfriends and et cetera, et cetera. So you could get, again, the same sort of either change of residence or removal of access.
Correct, because one of the primary consideration in our Family Law Act in parenting matters is the ability of a parent to maintain a meaningful relationship between the children and the other parent.
Oh, excellent. Thank you very much indeed. If we can now come back to Hong Kong, and in Hong Kong, how have the courts dealt with the actual statute
So
legislation?
in preparing for this talk, we went through recent judgments, meaning 2018 to 2023, so the last 5 years. We found 102 judgments relating to disputes on custody, care, and control. And just looking at these statistics here, it looks like it's not that rare for a sole custody order to be granted to the father. There were 18 cases. There were 21 cases where the parents were awarded joint custody, but the care and control was granted to the father. And in a further 7 cases, the parents had joint custody and shared care and control. This in total makes up close to 40% of all reported cases over the last 5 years. So it seems like there isn't a very heavy bias against fathers, but what these statistics do not show is the thousands and thousands of cases that don't actually make it to trial and to the court. And it also doesn't show the very long and stressful and emotionally exhausting journey that many litigants, including fathers, have to go through in order to get to this sort of outcome. It can take years, and they have to attend multiple interviews with social welfare officers. And they often come to us reporting like they feel like there is an inherent bias against them, like they have to work so much harder just to prove that they are worthy as a parent and on equal par in terms of ability and caring for the children. And then they have to go through the trial itself, which is a very high stress process. You get cross-examined. It's a process that is specifically designed to incite doubt. And so this is not reflected in the statistics.
Okay.
And in our analysis of recent cases, we looked at in what circumstances were fathers granted sole custody. And similar to Australia, in these cases, there were significant concerns about the mother's mental health. When there are concerns raised about either parent's mental health, the court often appoints a clinical psychologist to investigate the matter and to report back to the court. Now, in some cases, there were specific diagnoses, and others there weren't, but almost invariably, the clinical psychologist would report observations of behaviors which suggest that the mother was unable to cope with parenting responsibilities. For example, uncontrolled rage, abusing the children, including unduly harsh discipline, and for the mother to hold a job. So her behaviors were inconsistent with her ability to basically provide a stable environment for the child, and a lack of awareness as to the impact of their behaviors on the child. I've also highlighted employment status. In some cases, it was observed that the mother had a job which made it almost impossible for her to be the sole custodian, let alone the parent with care and control. In one case, there was a mother who was a domestic helper. Her ability to live and work in Hong Kong was entirely dependent on having a specific visa with quite stringent conditions on where she could live and work. So on a practical level, she simply could not just duck in and out of work or host overnight staying access with the child. And in other cases, the mother was unemployed. I've also highlighted accommodation. So as mentioned in that case where the mother was a domestic helper, she wasn't able to provide suitable long-term accommodation for the child. Now, in terms of cases where the fathers were granted sole care and control, a lot of the time it was down to the child's wishes. So if the child was deemed to be of an age and mature enough to explain their wishes coherently, the court would usually take this into consideration. And
in Hong Kong, what's that age?
Around 9, we found. Around 9 and above. Usually the courts would pay more weight or give more weight to a child's expression.
But increasing as the child gets older, obviously.
Yes. I think younger than 9, it was unlikely that the court would give too much weight to a child's wishes. It might be recorded in the judgment, but it didn't seem to have a very strong weight in terms of the judge's final decision.
What's the magic with 9?
It doesn't seem like there is a particular magic, but we just looked at the ages of the children in the cases, and it seemed like after 9 years old, the court would pay more attention to what the child wanted.
Okay. Could I ask, litigation here over rights concerning children or parental responsibilities concerning children, to what extent does the government provide expertise by way of social welfare officers' advice and the like?
It seems quite spotty, to be frank. When we look at the cases, it seems like with many of these cases, many of the families are quite dependent on social services to try and help them in various aspects of their life. But it seems like the extent to which these social welfare officers can assist is not very much.
Okay, and in Australia, if I can go back to Australia.
We don't really have, like in the family court system, social, whatever they call it, welfare officer
Social welfare officer.
In Australia. What we have in parenting cases typically is we have single experts, as I mentioned earlier, who will prepare reports for the court and to assist the parties, giving recommendations to the court in terms of what the parenting arrangements ought to be on a final basis. We have family consultants within the court system, which take similar kind of role as those single experts, which are usually privately funded. So family consultants are the internal one within the court system. We often send parties to go and see a family therapist to see whether or not that could provide them with some assistance in terms of working with each other in a parenting kind of capacity.
Okay, but in Hong Kong, your social welfare officer then in many ways acts as a single expert.
Yes,
Makes
wearing
it
many
as if-
hats in terms of trying to achieve what they can with the limited resources and the time that they have.
Okay,
Okay,
good.
we have that in Singapore too.
Yes, if I can, yes.
Actually, the court does devote a lot of resources to having our own court counselors and all. And the system is so interdisciplinary that we have found that our counselors are very swamped. So it takes a long time to get a report out. And one of the things that our legislature has done is that they have allowed for judicial interviews. So in part of the reforms that were just announced a couple of months ago, part of the judge-led powers that we have on top of triaging and being able to make orders even though no one applies for it, innocuously, there's a subsection that says judicial interviews of children. And we have interviewed children, yes, 9. Our presiding judge in a talk actually did tell us that she has interviewed a child as young as 5 years old. We have a lot of faith in our presiding judge, so it's okay if she does it. So I have to be correct here. But there are judges that we have a lot of concerns with, that we spend so much time and call for so many reports, and the judge hearing the case decides that I just want to interview the child, and the interview takes all of half an hour, and that was the make or break. So that's really tough on us.
Yeah, all right. No, difficult for me because my personal experience, if I could step in a second or two as a retired judge, is to be very careful interviewing children. Firstly, they're walking in, there's some old man with grey hair, I'm being personal about this, who is going to try and strike up some sort of immediate, relaxed conversation. It's impossible. The child, especially a child of any age at all, is going to appreciate, this is my personal view, is going to appreciate that it's there. It's going to have a great sense of guilt as to, is it betraying its trust towards the mother and or the father? And it will say what it thinks it should be saying, be it a boy or a girl. I'm not saying that always happens. Other children will say what they want to say. but they will say what the immediacy of the moment, maybe that week or anything else, also dictates. And it's a very artificial exercise. I think you have to trust the people who are properly trained in these things and have had the time. But you know, that was just my approach to it. Could we look at China as far as the actual workings of the court is concerned? Jason, where are we? Sorry, Jason, you've disappeared behind the French there.
I'm still here.
Yes.
Well, well, in China, when it comes to the child care and control, as I mentioned just now, if the child is 8 years old or older, the court will take into consideration of the child wishes. But in the cases that I have handled, so not in every case involving 8 years older children, the judge will do an actual interview. But I heard that from other colleagues, in some cases the judge did interview. That will not really call the child into the courtroom. They might have some private conversation with the child. But as said by our moderator, I understand it's probably not really very a good factor. Sometimes probably it's not really appropriate to consider the wishes of a child, because they are so easily influenced by the parents, especially at the time of the divorce. The child is generally living with one parent, right? So it's very easily influenced. And in China judicial practice, we do have the social worker regime. It's very, very rare, and this is where I think China is well behind the rest of the world when it comes to because I learned from in other jurisdictions that social worker can do so much, even after divorce, after they can facilitate the visitation and access by one parent to the other child, one parent to the child. But in China, we don't have such a social regime, social worker, or whatever you call it. So, after divorce, it's very often that the other parent who does not have the care and control will be easily left behind. And if that happens, and the law has very, very weak enforcement, to punish such unreasonable behavior. That said, our Supreme Court said very clearly, in the case of enforcement of child visitation, the court shall not enforce against the person of the child. All right. So the court will not take away the child for the access or visitation by the other parent. It does not happen here. So in practice, if one parent is left behind, it's very difficult for this non-custodial parent to fight for his right. As I mentioned just now, in most of the cases in China, the father are not the parent who have the care and control. So you can imagine, in China, the father are often the party who are hurt the most when it comes to the child relationship.
Oh, thank you very much. Thank you. If I could just quickly put an addendum to what I just said about judges. A lot depends on training, lengthy judicial training, not by sitting in a court for a long time, but by training. The problem we have in Hong Kong is you can be raised as a young judge on a diet of burglaries and assaults and find yourself transferred to the family court on Monday, and on Tuesday you're interviewing a child about whether that child should be under the responsibility of one parent or the other, with no idea of whether that child has been spoken to by either parent, because that often, in my few times I've been asked to do this, the children come in and they've both been given full set of instructions by the parents. So I just mentioned that. I may be wrong, it's a personal view only. Good, thank you. We've now reached a stage where we've got an indication here of the way things do work broadly. And I'd like to sort of throw the matter open for discussion if I could. If I could just throw in one other thing before I do that, and that is the question of guilt. Now, you may say, what's that? One of the things I'm often being concerned about is that children feel a great sense of, or some children, especially the younger ones, middle year ones, feel some degree of guilt about the breakup of their parents' marriage. They feel it's their fault somehow. And they will cry when they leave their mother and make it look as if they're really upset, and yet be happy with the father a half hour later, and vice versa. It's a very difficult issue. And I think that's one of the issues that often raises its head in these contested custody matters. Right, does anybody have any questions that they would like to put either directly or through the internet?
Can I ask a question about sort of comparative, practical aspects? When advising fathers, I mean, I think a lot of people in this room will have different views, but when advising fathers in Hong Kong, I would find out there's a cultural bias. It's not a legal bias. The law appears very equal and fair, but there's a cultural bias in that when you walk around Hong Kong and you see how things work, you go to a school activity or something, do you see mothers there more or fathers there more? And that goes into a judge's mind. And when acting for a father, what I often find is we have to over-prepare. You know, as Natalie says, you have an assumption against you and you have to fight against it. And what I often think, and I want to sort of throw this out as a question to China, Australia, and Singapore, is that in other places, the culture is set up differently. In Australia, for example, there is very little domestic help and drivers. So parents end up having to culturally, physically, for like in terms of historical chronology, the father has contributed towards the child's life. It had to happen. There was no other way. Whereas in Hong Kong, you have domestic help, you have drivers, everyone has a career, she's expected to take up the residuary childcare, and the father might contribute very little. So, I mean, what I'm wondering is in Singapore, China, Australia, do you have less of that bias? Is it still there, or is it even worse where, for example, a father who doesn't really take care of the child ends up having a bias in their favor, whereas assumed it's equal, and it's the mother who has to prove this person doesn't do anything?
Okay, Kai-Yun, we'll start with you. Is there an inbuilt bias, do you think, from the way things used to be?
Okay, we are still in the used to be, because in Singapore it's so easy to get help. The truth of it is that for most of us, both the father and the mother do work, right? And at the end of the day, somehow the bias or the understanding still is that the mother will be the one to decide what we eat for dinner, how we train the helper, when are the play dates. And, you know, he's right that when we go for parties, it's always the moms bring the kids along, even though both fathers and mothers are working. It's true that there is a trend maybe of the father who doesn't earn as well or being a house husband to be more involved. But because the judges don't see it and the counselors don't see it, it's not easy to draw that out in a report. So I guess there's still that bias, and that will stay with us for a while.
Yes, may I ask about Hong Kong?
I think in Hong Kong, it's quite similar. So we do, for one reason or another, mostly economic reasons, both parents work to support the family. And very similar to Singapore, it is often assumed that the mother will be the one able and willing to adopt more flexible work arrangements in order to work around the children's schedule. And I think maybe mothers are more, tend to show themselves as more organized, so they have a long. we do find
There's the bias there.
Yeah, there you go.
So Perhaps they have already started collecting a log of what they have done, so they know all their the teachers' names, the names of their best friends, and I think that perhaps lends itself to being more able to show off one's parenting abilities when it comes to litigation. I think that's what we find in Hong Kong.
And Australia?
I think comparatively we are less biased than our friends in other Asian countries for reasons that Jeremy has mentioned, and that is it's not as easily accessible for us to have domestic helper on a full-time basis, especially sitting at home. So a lot of the times nowadays where both parents need to work, they need to share the load during the relationship in terms of running the children around. I guess also from a cultural, our country point of view, most of our organisations or firms now have quite generous parental leave policies. So it's not only the mother who would take maternity leave after giving birth, but typically, you know, a lot of organisations now would give parental leave to the fathers as well. So it's not uncommon for the mothers to take a period of time off work after giving birth, and then mum would go back to work, and the father would then take parental leave to stay at home with the children until the children reach a certain age, let's say 1 or 2 years old, where they then would be more comfortable sending the children to what in our country childcare centres rather than having domestic helpers. So I think with those type of cultural things in place, I have to say that we are less biased compared to Hong Kong and Singapore, definitely.
Yes, and
China
the mainland as well.
Yeah.
Yes. Any further questions?
And just on your point there, I mean, I find that enormous amount of women who are married and who want to work can't work because they can't afford childcare.
Absolutely.
Mm-hmm.
So you certainly get many women who, you know, if I can say middle class, who work and they can afford to pay childcare. But I think the vast number of women wouldn't be able to essentially afford to work because they can't afford the childcare. So that centres them, you know, back into that primary role of
But see, I have seen sometimes, depending on the nature of the jobs of the parents, sometimes from a financial point of view, it might actually make more sense for the mother to go back to work and for the father to be the stay-at-home parent for that reason.
It did in my case.
Yeah.
Yes.
So it goes both ways, I guess, is what I'm trying to say. But certainly that because we don't have domestic helpers as easily accessible as, you know, our friends in other countries, it does have that trend, yes.
So I have a question, but it's relating to children's wishes. Can I
Yes,
just
of course.
over?
Yes.
Because I think in Hong Kong, I'm just interested where there's loyalty conflict and, you know, a court receives a letter from a child saying that I want to live with my mother. And then the next day, the court receives another letter saying that I want to live with my father. So then the court would enlist the help of the official solicitor. And I've actually acted and reported for one of these, you know, the children that's in these dilemmas. And it provides a new perspective. It's basically the child's perspective and wishes for the court to consider. So is there something similar in Singapore, you know, Australia and China, the official solicitors acting for the interests or representing the interests of the child in a children?
So in Singapore, we have the child representative who would then be the voice of the child. But what you describe is, it's unfortunately the reality in all our children's cases, partly because the system is such that when the parents go for mediation, the court already has got a set of counselors trying to talk to the parents and trying to talk to the child. If that does not work out, in the course of litigation, if there is a welfare report, again, the child gets spoken to, and then it's the child expressing wishes. And well, lo and behold, sometimes there is the judicial interview. And on top of all of that, if the courts find that, okay, the child keeps flip-flopping, let's get a child rep. By that time, the child would have expressed that same view a number of times, you know? And you wonder whether or not in a system that tries to give so much emphasis to the voice of the child, and I'm all for it, but where you place so much weight on it, you wonder whether or not that's doing fairness to the child. Because yes, you encourage parties to coach and to try and influence, and that's really bad form. But the system in itself is punishing that poor child as much as it's punishing the parents and the lawyers. So yes, we have that, but by the time we appoint that as the last resort, I always feel very sorry when we have to do that.
Yes, Natalie. Sorry.
I think in Hong Kong, certainly that's an avenue that is ready. I think it's not one that is readily taken all the time, because I think judges are aware of the sensitivities of involving the child directly in the process. I think, yes, it is quite an unusual step to move to get the child directly involved in the proceedings.
But how then do you really know what the child wants? The child most of the time probably wants mummy and daddy to be as they were and to continue to love both of them. Okay. But but sometimes that's not possible, and there have to be difficulties. How do you do that? Do you do that through a mediation? But that's not really the vehicle. At least with a child's representative of some sort, you can then give to that person your genuine thoughts once you have gained that person's, or you've got confidence in that person, as opposed to bringing them in at the very end, by which stage you're broken and fractured.
Like I don't think it's about an issue of what the child wants. I think that is one feature of the whole picture.
I agree. Yeah, absolutely.
And I think one of the difficulties, or one of the problems, is that people have a bit of a reductionist view, in as much as, well, what are their wishes? I mean, we hear this term all the time. And certainly, I can't speak for all of Australia, but certainly in Queensland, that's a term now that it's pretty well avoided. It's pretty well avoided because historically there's been this tendency to try to find out, you know, what the child wants. And what the child wants can often not be in the child's best interest, or what the child wants is important, but there are many other factors that need to be taken into account. So I think sometimes we put too much emphasis on wishes.
Yeah, that's a very good point, because it seems to me that the one fundamental principle is the best interests of the child, not the wishes of the child.
I mean, wishes is only one of many factors under our Family Law Act.
And will depend on the age of the child.
Absolutely. And we certainly do not have anything like our friend in China to say, well, once you reach 8 years old, and then that's it, whatever you say goes. Going back to the question though, with the independent children's lawyer appointment, you don't get a child representative appointed in every parenting matters. It really only is in some cases where the court thinks that one is required. Typically when there are no, significant allegations of abuse issues, it's really just an argument over time, then you don't, and both parties are legally represented by competent lawyers, then one would not be appointed. Wishes can come out in many different ways. It could come out, if there's an independent children's lawyer appointed, then it could come out through that independent representation. It could come out from the single expert interview reports that I mentioned earlier. The child representative, though, doesn't mean that he or she must go and tell, even if a child says to the representative, I want to live with mum or I want to live with dad, the role of the independent children's lawyer is to make an independent decision and recommendation to the court in terms of what is actually in the child's best interest in this particular case, rather than representing the child as such to simply convey the wishes.
Yeah, that's good. Any further questions at all?
Just one point, in Hong Kong, several years ago, we had a really excellent child forum, talking about the rights of the child, and there were many young people represented in that forum who put forward the representations that they felt the worst part of the divorce process was that their voice was not heard, in fact. And therefore, although a child might not always know what's best for it, if you're not going to completely exclude a child from the process and make the whole process even more bewildering, you have to have an avenue for a child to participate in the process. And the children at that forum were saying one of the most important things for them was to have the ability to talk to the judge, even if the judge wasn't going to do as they said, which is why should the judge do so. But it gave the child the opportunity to articulate something to somebody so that they had a voice. I don't think that should be lost entirely, even if people don't think the child should be able to choose. They should at least be able to participate somehow in this very bewildering process for them.
Could I ask this, and just both of the speakers and of anybody else on the floor? Is it accurate to say, even broadly, that those societies where the traditional roles have fused are more likely to be more neutral in determining fathers' abilities to have parental responsibilities, whereas societies which are still traditional in their roles are less so? I'm saying this quite honestly, all right, I'm 126, I agree, but nobody expected me to change a nappy. Not because we had servants or anything, it was just, you know, I played football with my kids, I didn't change their nappies. Today, most young men in many societies will do that sort of thing without thinking about it. They will play a very positive role. And I wonder if old judges of my generation, and most of them still are older rather than younger, might ignore that fact that today parents, whether they're the mother or the father, both play in their own ways very equal roles in raising their children. And I don't know, would that perhaps be right, or must we wait for that to happen here before we start to see a difference of opinion coming from the courts? I don't know.
It's also, I would say also a matter of evidential credibility, because if the judge believes that's what you've been doing, that's one thing, they might rule a certain way, but in Hong Kong, it's often quite hard to convince the judge that that is in fact what's happening. It will often be said, oh, you're making this up, you're only saying this now, that's not what actually happened. So I think culturally, if judges go out in the world and see it happening before their eyes amongst their friends, etc., then it's probably a bit more credible when someone comes along and says an affidavit, puts in an affidavit. Whereas if that's not what you're used to, and you see an affidavit, it's a bit hard to believe. I think that's what it comes down to.
Excellent. Yes.
I think in terms of proving it might be quite difficult, as Jeremy says, if the judge is inherently going to think it's unlikely that you've been changing all the nappies. I mean, how do you go about proving that you have, and apart from like setting up a video camera, all the nappies I've changed? And I think in that sense, it also unfortunately encourages like a battle of evidence and photos and videos of who's done what, which I think sometimes can be unhelpful in terms of resolving what is best for a child.
It's the problem, of course, with more traditional societies, that the courts tend to follow, to some degree, the norms. You had judges in Australia shot, family judges. And it's been my understanding from the history of those, they were people from very traditional societies. Certainly in one case where, one case I think was just a nutcase, but the other chap was from a very traditional society in Eastern Europe. You know, and to deny the father a particular right was sort of, you know, that was swords are drawn sort of thing. So if we have societies where we recognize equality in the raising of children, it may change things.
Of course, one can only hope, but I wonder whether if we didn't have what Australia has, which is to have it top down and done legislatively, that if we waited on the ground for judges who were all brought up by their moms and counselors who are too, and only saw their dad doing video stuff, right? So you wonder whether or not by creeping slowly by slowly, will we ever get to that? Because it takes so much for that societal change to happen. So one can only hope.
Yes.
Can I just say on that point, I think we are very lucky to have that framework. But having said that, language is everything. And one of the biggest difficulties we've struggled with since 2006 really is about how the sections were actually raised. So while it's been incredibly useful, we've got these identified factors that assist the court in making a determination about what's in a child's best interest. The way it's worded has led to an enormous amount of grief. It's led to a belief that there's been, that it's caused an escalation in domestic violence, that it's caused an escalation in no contact orders being made where there should have been made because of, for example, one of the primary considerations, as Eleanor said, is the child's to have a meaningful relationship with the father. So that then gets in the way of trying to really form a view or make an assessment about should a child have a relationship with a parent who's actually abusive. But because it comes up number one, and in fact for many years that was argued by counsel, it's number one here, therefore it's the most important. And it's took years for us to get case law that actually said, no, that's a bit of a nonsense. That's not the case. So language is important. The factors have been fabulous. They've helped the single expert witnesses, sort of draw or focus on what are the factors the court's going to look at. But the language, the flip side is that the language has caused a lot of grief.
Which brings us back, I suppose, to the comments I made earlier, which is you say to a client, well, we're going to deal with the question of custody now. And the client automatically thinks, well, custody, that means I've got control of it. I decide where it's going to go, what it's going to do, where it's going to stay in a cupboard or whatever. And that doesn't mean that at all. And then when you say care and control, you think, oh, control, that also means, no, that doesn't mean that at all. And you're having to re-educate every lay client who comes in a most critical time of their life. And so you're right, I think, that words can mean everything, especially in circumstances like this. And our draft legislation, as I understand it, has been wallowing in a slough of despond for about 25 years.
The terminology, actually, the cryptic sort of terminology, is almost one of the first things one sits down with parents and explains, because otherwise the rest of your advice makes no sense. So you start with, ignore what these words literally mean. Here is what they actually mean for. So
Yes.
it's almost a matter of, do you go to the right lawyer? Do you go to the wrong
Yes, yeah.
It's very confusing for lay people. But not everyone sits down and says, look, before we go on with the rest of this, here is what these words actually mean. I think that's very important. It's unfortunate because unless we change the law, then having this system where if you go to the right people and get the right advice, then you will understand the situation. But if you don't, then you'll be very confused about the whole situation from day one, right from the beginning.
Could I just add to that it's not just the words in legislation, but lawyers being lawyers, we would also argue based on the words in case law. So like in Singapore, the case that gave shared care, the judges always say that this happens in cases where there's cooperation because essentially the child has two homes. Of course, what then happens to all mothers who don't want to give shared care is to start a fight and create acrimony, right? So for those of us acting for the fathers, we then try to argue that, look, surely you should make an exception for self-inflicted acrimony. But it's all of us playing around those words, being listed first is the most important criteria. So arguments like this do complicate the issues, especially when we are trying to ascertain what is in the child's best interest. But I suppose that's what clients do pay us to do.
I think while we are taking questions from the floor, Michael, maybe you have to look at the back. There are questions from those who are attending
Oh,
on
I'm
Zoom.
so sorry.
So, yeah.
Okay, well, let's start with CW. How likely can a custody order be reversed and on what basis? Any cases to share? Hong Kong.
I would say it's not easy to completely reverse a custody order, assuming it's a sole custody order. I think there would have to be quite a fundamental shift in the circumstances to justify reviewing a custody order. Remembering that in Hong Kong, custody refers to parental responsibility to make high-level decisions. So something must have gone quite wrong, I suppose.
Yeah, I think that would also include sort of custody, care and control.
Yes.
Yeah. I think any major event in a child's life or a major event in the life of the parent who has parental responsibility can give grounds for a change in that parental responsibility. If for example, a mother who has care and control and a full parental responsibility marries a man who's abusive, who is guilty of assault and various things like that, then it's almost remiss not to go to court and seek a change. So I think the answer there would be yes, it can be reversed, but it would have to be a significant event affecting the child and the life of the child. For what it's worth, in California, there's a strong leaning towards equally shared physical custody. I think that's actually, I'm aware of that in California, but I'll ask if you would agree. It seems to me that that's a very strong movement in other jurisdictions too, England, Australia, very much. And could I go back up a bit? Sorry, again, I think I missed the first question. I'm wondering how do the respective jurisdictions deal with non-compliance? Well, again, please forgive me if I'm jumping in and hogging this, but one of the reasons why earlier I spoke about the English court and a lamentable judgment by an English family judge saying the one parent is just hopeless, is not complying with anything, but what can I do? Because the social welfare authorities say that that parent is the better parent of the child. But if they're non-compliance, it indicates that the child requires the other parent's care and control as well to some degree. And if you're denying that, you're undermining it. And as they said in Canada, no, we just change the order. If you're not going to comply with it, then you've got to expect drastic things to happen. And to me, that would make sense. Yes.
I think the change of residence that you're speaking about probably happens very rarely in Hong Kong.
It may do, yes.
Yeah.
It may, but I don't think you can simply sit back and say to a parent who is seeing no common sense at all and who is perhaps themselves under some sort of emotional constraints that they cannot rid themselves of, to just keep saying to them, look, next time round, make sure that little Johnny is going to be ready for, for his weekend time with his father or his mother. I think the court has to be stronger than that when needs dictate.
I think in Hong Kong, apart from sort of actually changing the order, we also have enforcement by way of the social welfare department knocking on your door or even committal contempt of courts. But one of the things I wanted to sort of ask Jason, is that this is something I've sort of heard over the years from various experts, etc. Hong Kong mainland, we are right across the border from each other. We're sort of all part of the same country. We have reciprocal enforcement, and yes, our understanding in Hong Kong is that the moment a child crosses the border, there will be no aspect of physical enforcement. So no one will knock on your door, no one will arrest you, there is no contempt of courts, and if you breach children orders, it's basically free for all. There's nothing you can do about it. Unlike, for example, Hong Kong, where you could, for example, get the mother arrested in the middle.
So I'm not sure whether I have heard you clearly. You're asking about could our moderator we just recap the question a little bit, yeah. So I can clearly understand the question, yeah.
I was asking about the enforcement, the physical enforcement of childcare orders in the mainland.
Yeah.
What happens if someone doesn't comply? Does anyone knock on your door, take the child away, arrest the parents, anything like that?
No, it won't happen. You won't happen them. As I said just now, the court in after divorce in the enforcement stage, if one parent is denied access to visitation by the other, the court we never do things like that. Take away the child for purpose of for the other parent to visit or access. China Supreme Court has made it very clear that the court cannot enforce against the person of the child. That in practice, if the one parent does not comply with the court order, what the court can do for blacklist that parent who has the care and control of the child in a social credit system. I myself have a client who was blacklisted that way. When she applied for a mortgage loan from the bank, we find out that he was actually blacklisted. So that's the one thing. But and of course, if you look at what the law says, the law might take a more drastic measure, like detain the other parent. But it does not really happen in practice. So it's there's no effective way. Actually, this is a part where China is not very good at when it comes to the child protection or protecting the right of the access to visitation after divorce.
Okay, there's a question here. Any protection that the child cannot be removed from the jurisdiction during ongoing proceedings, does that exist? Australia?
It is a breach of our act if children are removed from Australia out of the jurisdiction whilst there are ongoing parenting proceedings on foot, unless there is a court order permitting so, or by agreement between the parties. So it's actually a breach of our act.
Okay, so it's Hong Kong.
Same position in Hong Kong.
Yeah. Singapore.
We have a 1 month period that you can travel with the kids if you have care and control, even whilst there is ongoing litigation, unless the court provides otherwise.
Okay, good. And let's have a look. Where are we?
I think it should be the last question.
Oh, sorry, yes. Okay, should be the last question.
Yeah, because it.
And in China, Jason, is there any order that you cannot remove the child while litigation is taking place relating to the child?
Reverse the custody order?
No, actually physically removing the child from the mainland, from People's Republic.
Well, I think you can. I think that's something you can do, but in China, the law is not that clear regarding the decision where the child should be living with. Okay, as I mentioned just now, China court will only deal with care and control. The custody issue is presumed to be jointly owned by the parents. Even after divorce. But that said, our law say when you apply for a passport for the child, it requires both parents, consent. But after that, if the parent have the passport and want to take the child out of China, I don't think there's any effective way to prevent that from happening.
Okay, good.
So thank you so much, all the speakers, and I hope you all enjoy this wonderful generous sharing session about fathers' rights. And I know you have more questions. You might stay. We have drinks over there and snacks over there. You can stay a little bit longer. And not too long. And then next week, the same time, we have another session. It will be run by Ms. Robin Howarth and Ms. Laura Lee. They are both on Zoom. And they will talk about the psychological impact on the relationship breakdown to the children. And like when the children are not spending a lot of time with the father, what's the impact? Or like when is the best time for the father to have more extensive time with the children? So that will be covered in the next session. I believe most of you have signed up for next one. If you have not, please do sign up for the next one. Again, it will be here with wine and snacks. So I think it is very important in Hong Kong. So thank you very much.
Apologies, there were a number of questions there and I may have missed a couple. It's not bias on my part, it's just incompetence. Okay. Thank you very much.
Thank you.
Let's see what we can do. Yes.
Michael, I would like to give you a small present.
Oh,
Thank you
very
so
nice of
much
you.
for your
Thank
time and
you.
generosity. And then Ms. Wong.
Thank you.
Thank you. And Ms. Lau.
Oh, thank you.
Ms. Lau.
Thank you.
Thank you. Thank you, Natalie. You have done.
Bias is everywhere.
No. Thank you, Nat. This is her first time. Great. Thanks. Thank you.
Thank you very much.
Thank you, Jason. I'll give you a box of chocolate.
Where's my present?
I will give it to you when I see you. Thank you, Jason.
Bye.
Thank you.
Well done.
Thank you.